Good day and welcome to Nishith Desai Associates webinar on Insolvency and Bankruptcy Code 2016, Impact on Bondholders, Investors and Companies. As a reminder, all participant lines will be in the listen-only mode, and there will be an opportunity for you to ask questions after the presentation concludes. Should you need assistance during the conference call, please signal an operator by pressing star then 0 on your touchtone phone. Please note that this conference is being recorded. I now hand the conference over to Mr. M.S. Anand. Thank you and over to you, sir.
Thanks, Ali. So, welcome everyone to the bankruptcy event on the bankruptcy code. Welcome to those who have joined on the call, and welcome to those who are here in Delhi. So, to start off, we'll have a brief introduction by Pratibha Jain, partner at Nishith Desai Associates. She is the head of the regulatory practice and partner of the BFSI practice at Nishith Desai Associates, followed by a brief talk on the code by Mr. T.K. Vishwanathan, and then we'll have the Q&A session.
Thank you and welcome everybody. We are very fortunate to have Mr. Vishwanathan here today with us. He, as most people on the call will know, that was the chairman of the Bankruptcy Law Reforms Committee. People might not know that he's held various illustrious positions in the government over the years, and I have personally a great respect for his legal acumen. He's been the law secretary, he's been the Secretary General of the Lok Sabha. He's presently the consultant to the President of India, and many people might not know that he's been the leader of the Indian delegation to UNCITRAL for a number of years now. So, an interplay between bankruptcy code and how we will resolve issues around the Indian litigation system, which thwarts any legislation that needs to work effectively. So I think you would have put in a lot of thought into this issue too. So we are very grateful for having you here today, and also when the bankruptcy code was being drafted, knowing that you were at the helm gave us a lot of comfort, and that shows in the code when it came out. It's a very well thought out piece of legislation, much needed. The history of the bankruptcy proceedings in India, apart from just practically how it's worked in the past in terms of delays, I think more importantly, we've never had one piece of legislation that dealt with all the issues that encompass such a proceeding. It was spread across Contract Act, your company law, your PFIR. There are about half a dozen various laws and regulations that covered it, and then accordingly the authorities that covered it. The bankruptcy code is a very much needed legislation to bring all of that into one place and centralize the whole process. In fact, yesterday I was speaking at a FICCI event on capital markets, and the additional secretary from Ministry of Finance was talking about the importance of the revival of debt markets in India, or growth of debt markets. I can't really say revival, because we've really not had a buoyant debt market in India, and a key to that really is an effective bankruptcy system. So it affects anybody who wants to invest in India, anybody who's already invested in India, anybody who's has a company in India and hasn't been working well. So the ramification of it is quite widespread. We might not be able to cover all of it today, sir, but the kind of just to give a sense of the people on the call with us in the room, we have corporate professionals, investors, and so really the focus, and a lot of people from various banks. So really focus on creditors' rights, how creditors' rights will be protected under the new regime. What is the distribution waterfall and how will it actually get practically enforced? We understand that the National Company Law Tribunal has been constituted recently, but we are still appointing the judges. So how do you see that process getting laid out and the timelines for that? The bankruptcy board has also been constituted. But just understanding also, practically how do you see all of this being laid out in the near future, and how quickly do you think we can have the regime being effective? I think those are some of the key issues that we would want to discuss today. With that, if I can just ask you to, just kick off with the thought process first behind, because always with the new legislation, we would like to understand what the committee was thinking, what the lawmakers were thinking, so we understand the intent and accordingly interpret the legislation.
Thank you, Pratibha. Thank you, Mr. Anand, and good evening, friends. When I was assigned this task of drafting a code, a bankruptcy code, and I was made the chairman of this Insolvency and Bankruptcy Committee, Bankruptcy Reforms, Law Reforms Committee. My mandate was very large because I have to cut into many statutes and try to bring under a single umbrella the bankruptcy of corporates, insolvency of corporates, then partnerships and individuals into a single code. This in the beginning appeared to be a very daunting task because India has a very large statute book and we have many acts, each working at cross purposes with each other. So the task of identifying each one of them and then trying to bring them under one umbrella proved to be a very difficult task, but we achieved it in a record time. As Pratibha said that we don't have a corporate bond market mainly because the recovery rates for debt, corporate debt is very poor because the system is so bad, and we don't have a single law which deals with bankruptcy or insolvency. We have this Companies Act, and with this official liquidator's office, it takes many years for a company to be wound up and the realization of assets to be taken when the siphoning off takes place. And we had very bad experience with SICA, the BIFER, where people use BIFER for the automatic stay and abuse of process, and when the debtor in possession regime led to a lot of abuses. So we had to address these issues, and we also had to think about a situation where all business failures is not equated with malfeasance. It's not necessary that every time somebody defaults and then if market failures are common in any market economy, it's not necessary that everyone will succeed. But in India, unfortunately, for various reasons, default business failure has been equated with malfeasance, where it is equated with the promoters siphoning of assets and then the banks getting into that. The main reason for that, in India, we don't have a bond market, but in Western countries, they raise money from the bond market. They require them for running a business. We have to depend upon the banks and financial institutions in India. And this has led into a lot of difficulties. It has brought its own difficulties. The banks have gone into difficulties, and then people don't get easy credit. Earlier, 2 attempts were made to reform this bankruptcy law. 2 committees were there, but then those committees, though they did a good work, they did not succeed because they didn't come up with a code. So we thought this time we should have a code which is passed by Parliament and which is put on the statute book under one umbrella, so we will be able to. Now the main thinking which permeated the entire thought process is, first, business failures are normal part of market failure. People should be able to come out, wind up, then start fresh again. So this should not be held against them. Secondly, we should also ensure that there is no siphoning of assets during the time when there is a default. So we wanted, instead of debtor in possession, the control should pass on to the creditors committee. Then thirdly, we should also ensure that people should be encouraged to take risks. Limited Liability Corporation, Solomon was responsible for the great advances after the Industrial Revolution. Most of the progress, economic progress, is due to the House of Lords decision where people were encouraged to take risks and then get away with that if it failed. Similarly, we wanted to ensure that people are encouraged to take up risks, and if they are not successful, they should wind up and go away. This is the thought process. Now, as you had a very bad experience with the judicial system, all of us have this difficulty where judicial delays. You have, whenever you go, you have these court systems. In spite of the legislative prescription that they should not grant adjournments, things go on, they get prolonged, and then nothing is completed within time. And this results in asset destruction of value of the assets, and then there is nothing left for the creditors. And then the whole thing went up in such a way. In 2002, the government came up with the SARFAESI Act, Securitization Act. And that has also not succeeded because in spite of the Securitization Act, people are not able to realize the security and walk away. It has been stuck into various cross litigation, and it has end up thing. With the bankruptcy code, there is a thinking that we should also do away with the Securitization Act. The code should contain everything, and then people should come under the code and realize their assets. This is thinking, but then we thought time is not very ripe for us to touch the Securitization Act because the banks and others were all very much keen to have it. But there is nothing in the code which compels a security holder under the Securitization Act to come under the code. It doesn't compel anybody, but if he comes out, he forfeits his right, he gets a higher waterfall provision here. Now, having said that, the think process, we structure that code drawing lessons from UK and USA, and then the whole game change is from the resolution professional who is going to be in charge of running the affairs of the company once the resolution petition is admitted by the tribunal. The National Company Law Tribunal will be for corporate insolvency, and the Debt Recovery Tribunal for individual and partnership firms. There is a lot of criticism as to why you have conferred this individual bankruptcy jurisdiction upon the debt recovery tribunals, because they are already don't have a poor record, and then it may not be able to meet the challenges which are facing them. We knew that problem, but then if you want to create a separate tribunal to confer this power of individual bankruptcy upon corporate and a company law tribunal would have been too heavy for them to manage. So the company law tribunal already was late by more than 10-12 years. So we thought we should not disturb that structure, and we thought we will re-engineer this debt recovery tribunals in a very big way. Finance Minister assured us that he is going to re-engineer that, and he has done that in the latest amendment to the Securitization Act. He has done a lot of things to make it an online code, electronic transmission of documents, and then also to bring in cross litigations, and the debt recovery tribunal will adjudicate upon leasehold rights and third party rights. Now this code, anybody can file a petition for insolvency. The financial creditors, the operational creditors, and the corporate debtor himself can file. There are different eligibility for different risk requirements for filing the petition. And when a petition is filed, the resolution professional is appointed, interim resolution professional is appointed, and the management of the company is shifted under section 17. Immediately the management of the company is shifted, and a committee of creditors will run the show. And the decisions of the committee of creditors will be by 70% of the voters, creditors voting. Now, there is also thought that, in US they have a problem because the high value creditors used to muzzle the people with lesser value. So they said, but we thought it is too much to address that in the code itself. Let us leave it to the creditors to deal with the issue. The second most important thing all of us face is things should not get clogged in the courts. See, whether a company can be revived, it kept as a going concern, or it should be wound up, is a market decision. It should not be a judicial decision. That was very firm in all the thinking. There is no point in judges sitting over and deciding whether the company can be revived for the sake of the workers, or it should be wound up. It's a market decision. Creditors are the best people. They have the financial stake. They should decide it. And once they decide, the tribunal only has to approve it. They should not sit in judgment. They have very narrow grounds on which they can question the resolution plan or the liquidation order. The whole thing is time bound. Timelines are sacrosanct. People are very skeptical when I said we have provided timelines. You have to have 180 days plus 90 days is outer limit, and for fast track it is 90 days plus 45 days. This will never work because the tribunals and the courts don't adhere to your timelines. But we said this has to work. If timelines are fixed, then the whole thing will not work. And if they don't pass orders within a particular, everybody has to act within some day. Suppose the tribunal wants some resolution professional to be nominated to the board has to answer within 6 or 7 days. They have to answer and appoint somebody. So everything is written. It's linked with the clock. Now, if judges don't decide according to the timeline, they have to give reasons why they have not done that. So we have imposed a heavy burden upon them to come out and say why you are not adhering to the timeline. And the resolution professionals are those people who will manage the entire show. The entire code, the soul of the entire code is the resolution professionals. And these are the people from different areas and different expertise. It's very difficult to straitjacket and find out that from lawyers, from accountants or bankers. You can come from different streams because there are different types of enterprises. The digital economy has opened up so many startups. We do not know the experience to run enterprises cannot be confined to any particular stream. So we have left it open, and the board, we have conferred a vast powers upon the board to recognize these professionals and also to discipline them. We don't want them to go the same way the recovery officers are working in the debt recovery tribunal. It's very, we hear so many things about how recovery process is delayed, siphoning takes a lot of that. We don't want that to happen. We want to have high class professionals, people who adhere to highest ethical standards, professionally qualified, and who are under the watchdog of a board, Insolvency and Regulatory Board, who will take care of that. There's another area where we are lacking. There is really delay is because not only there is a multiple judicial fora, there is no single law which deals with that. There is also a lack of information. There is information asymmetry between the creditors and the debtors. When a debtor goes into default and the creditor tries to enforce the security, and then you find a lot of third-party claims are all set up, and then you don't know the real valuation, the assets of the debtor. So all these things are very difficult. So we conceive we should have information utilities, and the latest law on securitization makes it mandatory for a security holder to get it registered in the central registry. So unless you get it registered, you will not be able to enforce the security. And the law has been amended also to enforce the district magistrate to enforce the security, to recovering the assets, and also to, if in case you want to take over the management, they should assist the banks and other creditors in taking over the management. Within 30 days, timelines are prescribed. Now, invariably you see, and this, only once you register with the register, you get priority over crown debts, that is over the government dues. That is something which is a great advance we have made in the code. Even under the insolvency code, we find the crown debts have been pushed down below the waterfall provisions. Section 53 provides for waterfalls and a distribution of the liquidation estate, where after the resolution professional expenses, and these crown debts come down below, and the unsecured creditors rank high. So the bondholders will come there. Now, how this code will encourage the corporate bond market, because bondholders will be treated as financial creditors, and as financial creditors, they will have a say in realization of the assets as a credit in the creditors committee. So and there will be good recovery rates for the bondholders. So we hope this will lead to a good corporate bond market and also a flourish. And there is another aspect which we are very concerned. In India, there is excessive dependence upon securities. The people want personal guarantee. So company directors are asked to give personal guarantee. So the people are only concerned, are more comfortable with the securities. With the result, you can't raise finance. There is no question of people looking into your cash flow and advancing project loans. This is a non-existent here. So this is causing problem. Everywhere you get entangled, the company goes into default, the promoters get entangled in personal guarantee claims. So this is something which we have to avoid. People should not depend upon the security for raising money. Now, in case a company director has given a personal guarantee and it goes into insolvency, it will not go before the debt recovery tribunal. To avoid multiplicity, we will be sucked into the company law tribunal, and the company law tribunal will handle that case also. So there is avoidance of multiplicity of fora has been taken care of, everything comes in. Appeals will go to the appellate tribunal under the National Company Law Tribunal and Debt Recovery Tribunal, and from there only appeals to the Supreme Court on a question of law, nothing else. The grounds on which appeal will lie on appeal to the appellate tribunal listed out the sections, and then from there to the Supreme Court only on a question of law. We have tried to amend as many acts as possible to take care of it. We have knocked out, we repealed the Provincial Towns Insolvency Act and the Provincial Insolvency Act and the Provincial Presidency Towns Insolvency Act. Both are old acts, 100-year-old acts, which are not functional. And then we have conferred the jurisdiction upon the debt recovery tribunals. And there is a criticism that you are taking away the jurisdiction of the district courts. There is no access at the grassroots level. Then we did provide for sitting of these debt recovery tribunals in every district headquarters in circuit sittings. It is under the section which it makes it mandatory for the debt recovery tribunal to go to every district headquarters and sit in circuit sittings, so that there is no challenge on the ground. Access to justice is being denied. You are taking away from the district court. There is no alternative fora. Again, it should not land us in a litigation. So we have taken care of that. And then these are the things which we have drafted this, and I will be very happy to respond to initial queries from all of you.
Sure. So before we do that, Anand, do you want to go a little bit more deep dive into, certain aspects of definition of creditors, and the distribution what fall under the Act, and the whole concept of committee of creditors, how will that work under, Indian system?
Right.
And, what happens to director liability, for example?
Sure. So to start off, sir, we note that, for a change, the code, unlike the earlier laws, which gave preference only to financial creditors, here, even an operational creditor who needs to recover money quickly so that his working capital is in flow, even he has access to an expeditious dispute resolution mechanism. But while for operational creditors, there is a mechanism where once the notice goes, the debtor can then say that he is going to initiate arbitration, or he can otherwise dispute that debt. But with respect to financial creditors, there is no such mechanism where the debtor has an option to dispute the debt. It goes on the basis that because there is a debt due and there is a default, under that mechanism, it seems to not comply with principles of natural justice.
No, I think this point we discussed, operational creditors may not have everything reflected in the information utility, but financial creditors, everything will be readily available. So
right.
You can't dispute and raise an issue there, try to delay it. So that is the reason why these operational creditors, because they may not, their dues may not be reflected in the utility. That is the main reason.
Okay.
That is the main reason.
So
and as far as financial creditors are concerned, everything will be, the debtors things will be reflected. So there is no question of disputing at that level.
Point of time. Okay. So sir, one of the things that you had mentioned was how you try to reconcile all the statutes, and there's multiple repealments and things like that. And in fact, in the Sarfacy amendment now, there is one with respect to, as you had mentioned, that the Company Law Tribunal can look into aspect of claims of landlord tenants as well, and it cannot be obliquely used for the purpose of money recovery or recovery of the property. But sir, what about rights of states under state revenues? Now to an extent that is going to go away now because of GST, but all the state VATs and all will get repealed. But do you foresee any problem if revenue laws continue to...
No, we have drafted section 53 in such a way, even those are overridden.
Okay.
Section 53 is very clear.
Right.
You said this was very much debated because most of the litigation is centered around from state legislation, state revenues.
Correct.
So 53 is very clear. Notwithstanding anything to the contrary contained in any law enacted by Parliament or any state legislature for the time being imposed. So we have foreclosed it.
This, okay. Sir, on in the code, we've made a conscious effort to give some amount of management rights to creditors. Now, this is something that even Pratibha alluded to. Before the committee, the committee of which you are the chairperson, there was some literature which talked about the pros and cons of that. I'd like to cite only two examples. One was maybe three examples. One was Chrysler in 1980s, when it was on the verge of bankruptcy, and then it went to Congress, it got funding. And more recently in 2008, after the financial crisis, it affected Ford, General Motors and Chrysler again. And again US Congress and the Canadian government invested. And then sometime in between both of these two events, there was Nissan. What the experience in the US, what they have seen is that at times like this, when a company is on the verge of bankruptcy, what it needs is capital. A close example of this is when financial companies were subject to stress test, telling the shareholders, you bring in money and we as government or lenders, we'll put in more money. Do you think that would have been, should that have been incorporated in the statute, or giving management rights to creditors will be more helpful, either in ensuring that it doesn't become bankrupt, or that a company which is on the verge of financial imprudence doesn't further go down that path and it's able to come back?
No, I think in US they don't have public sector banks like we have.
Right.
In such a situation, we can always handle through these public sector banks. This is how we handle it in our country. So it's always possible to infuse new finance through these financial institutions. But this we believe that financial creditors are the best person to decide how they will bring in fresh money. They are the best persons to decide, and we didn't want to address this issue in the legislation because putting anything in the legislation in India, everything gets interpreted and goes to the court. So we never wanted that. We didn't want to open this court to any judicial interpretation.
Right.
We just wanted this to be a straitjacket thing, should address only insolvency and bankruptcy related matters, and they should be handled only by these judicial fora. Nothing. It should not go to high courts. It should not go anywhere. It should be a straight thing, and it should remain like that. That's what we designed. So we were a bit careful in not bringing in external elements which would have invited us some criticism or some controversy or some debate, which will not be, it will distract from the main object of the court.
Right. So now related to the role of the creditors committee, there's a fine line, you also talked about it, because in India we have, especially after the Kingfisher episode, we have this tendency to view every company which is becoming financially insolvent as there being a case of mismanagement and deliberate mismanagement. So there's a need to balance the rights of the company, basically the shareholders and the company on one side, and creditors and society on the other. So, and when it comes to the invocation of the code, you're already very dangerously close to the path where you're looking at public good or probably winding up a little more. So how would you suggest that we should approach this so that the tribunal which is examining the books of accounts, the record, the insolvency professional who's going to make a case for revival, how should he make his case before the adjudicating authority, and what can the shareholders do to say that, okay, look, we know what economics says, but we've been behind this company for 20-30 years, so this is what we would like to do. So how do you think that balance of rights can happen?
These directors and other people, though they don't have a voting right in the creditors committee, they can be present there.
Right,
they
correct.
will be present there. Their voice will be heard. Even operational creditors, we didn't initially give them anything, but then the committee said no, they should be given an opportunity.
Right.
So they will have their voice heard there. And the most important function of this resolution professional is the preparation of the information memorandum, and he has to prepare that and resolution plan. So this resolution plan, he has to sit with everybody, and it has to be something on which there has to be a lot of give and take. And you see, and the only thing is an appeal can lie to the appellate authority under section 61. See, an appeal against an order approving a resolution plan under section 31 may be filed on 5 grounds.
Correct, very limited, very limited.
So it is limited. So if it falls within any of these 5 grounds, the tribunal will look into that.
Right.
So you have a remedy there. Beyond that, you have to live with the creditors committee decision.
Right. So the problem that we have seen is this, particularly under SARFACI, is when an asset was to be sold, when you had the 13-2 order, you'd go for auction proceedings. Immediately there will be an objection saying that the valuation is wrong, and then you will have collateral proceedings even before the magistrate can pass any order. You have a writ, then writ appeal, and then an SLP saying that there is a gross mismatch between the value which is shown and current market rate. Now we cannot prevent people from litigating, but what are the safeguards over there, the non statutorily entrenched safeguards which can be there?
All those cases will only come before the tribunal. It will not go to the courts now.
No sir, the writ petitions, because even when SARFACI was there,
now writ petitions will be closed.
Should be closed. Okay. Yeah. I think that is where we have seen a lot of.
And there is also a section which deals with extortion transactions, where we look back 2 years behind and see if you have done something, you are creating third party rights. You can always look back 2 years and cancel and nullify all those transactions.
Right.
So that is a very useful
that
technique.
We've had in I think transfer of property and in.
But then they were not very effectively used
for cancelling. Right. So
now with many of them are not transparent. Now everything will be reflected in the information utility.
Right.
So it will be very difficult to hide or create any interest with retrospective effect.
Right. So the finance minister had indicated that before the entire infrastructure is there in place, it be around 2017 for the whole code and the machinery to start working. Now before that, of course, there will be people who would want to understand the role of the insolvency professionals and how they can be part of this, given that they are going to play a very important role in the revival or the realization.
So, no, actually subsequent to this enactment of the code, there is an oversight committee headed by the Secretary Corporate Affairs. I am also part of the committee. We had 5 subcommittees who have worked overnight, and they have come up with regulations, rules, and also various things for the information utilities and for resolution professionals. And we have had the appointment of the board. Sahu has been appointed, is a very competent man who brings in a lot of exposure and experience from SEBI. I known Sahu for more than 21 years when he did the Depositories Act in Law Ministry in 1995. So they are all working together overnight, and hopefully by next month you will have the tribunal receiving the petitions. First application may be filed by next month, I hope, because everything is set now. Now we also provided a provision, transient provision in the code till the board comes into existence and then the resolution professionals are recognized and appointed, that government itself can recognize temporarily for these professionals and agencies who can handle these cases. Because without the professional, your court cannot start functioning. So we have provided that, and they are already in the process of identifying. To start with, we will have to have an ad hoc recognition, which will be later regularized by the board when they come up with the syllabus and licensing conditions. So that is already built inside the code, and I am very sure there is a lot of talent available even now, because we have been BIFER for more than 25 years. A lot of people are working in the operating agencies, and a lot of youngsters. I see a lot of people here. Many of them can qualify and then handle all these cases. And we will pick up as time goes on. The profession will become from different sources will pick up, and the board will be able to see that a very new profession emerges very fast.
Right. So one thing that the old statute and the regulatory framework did not provide for as such was the role of foreign creditors. Now here I think few days back the draft code for the banks and financial institutions, in that they have specifically said that priority should be given for local creditors. Now given that we do want the bond market to develop, do you think that there is requirement for any provisions in the code for foreign creditors, given that you are likely to have some issue with RBI as well with respect to either how much money is going out, the valuation, or anything like that?
No, we didn't want to have such a thing in the code, present code. We wanted to treat foreign creditors on par with the Indian creditors. We didn't want to discriminate. We didn't want to do that.
Okay.
Because already there is a strong lobby from foreign institutional investors that she should have the benefit of SARFAESI. They are lobbying for that. Because they also said we need to. So, but the thinking is the SARFAESI in the long run should go. If the code becomes very successful, SARFAESI Act doesn't have to exist. Because coming under the code, your realization will be faster than going under the SARFAESI.
So, not only that, when you come under the code, you act.
We have the next question from Navneet Jain from ASC Legal Solicitors. Please go ahead.
Good evening, sir. My question is, as per my knowledge, the code talks about the moratorium period. When the corporate insolvency or the individual insolvency starts. So I want to know that this moratorium period is an absolute that it, saves all the proceedings, whether it is civil, criminal,
Yes,
or it talks only about that credit only.
It's absolute stay. You see the moratorium, no legal proceedings during that calm period. Section 14, it deals with moratorium. The moratorium prohibiting all or any, all of the following, not only, all of the following. A, institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, order in any court of law, tribunal, arbitration panel or other authority. B, transferring, encumbering, alienating or disposing of by corporate debtor any of its assets or any legal right or beneficial interest thereon. C, any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of the property, including action under the Securitization Act. D, the recovery of any property by owner or lessor where the property is occupied by or in the possession of the corporate debtor. So it's absolute moratorium, section 14.
So it's same in case of individual banker insolvency also?
Just one second. Individual insolvency, I'll read out the.
Yes, sir.
Section 101 that provides during the moratorium period any pending legal action. No, it's slightly different. It's 1012 deals with that moratorium of individuals. 101, it says during the moratorium period any pending legal action or proceeding in respect of any debt shall be deemed to have been stayed. B, the creditor shall not initiate any legal action or legal proceedings in respect of any debt. C, the debtor shall not transfer, alienate, encumber and etc. These are only three. This is a bit narrow than what is there in section 14.
Okay, sir. Thank you so much, sir.
Welcome.
Thank you.
Thank you. A reminder to the participants who wish to ask questions, may please press star and 1 at this time. However, there are no further questions on the audio bridge.
Okay. Any questions from the audience here? So we have a lot of the leading GC luminaries in the room. So these are the people who are actually going to end up implementing and using the code.
Normally the financial creditors are, most of them are secured. The unsecured creditors, there is a bifurcation, it's a financial and operational, and this is a separate treatment for both of them.
No, there is no difference between the secured and unsecured creditors. So they are all treated equally.
And the committee comprises of both secured
Yes.
and unsecured. Is there any threshold limit for who can be a participant, or they have to choose among themselves?
No, it depends on the value of their credit.
So, practically, how do you see this actually playing out? Now, the NCLT is being constituted right now. Judges are being appointed. We have Delhi and Mumbai functioning.
No, NCLT is functioning. They are dealing with other cases.
Right.
It's a bankruptcy jurisdiction. They will start next month. But the tribunal is functioning. They are handling other cases.
And in terms of one of the concerns that the industry has is that you will have the same judges, the same professionals in a different garb now. So will we really be able to bring in the efficiency that the code needs, that the markets need?
See, this is a criticism against the judiciary also. Because this is where, see, you know, Jeremy Bentham said, judge-made law can never be better than the judges who make them. We need to get the best people. Then at least, whatever, there is a problem of manpower. And having got the manpower, at least now we have to train them. At least the second thing we can do is to expose them to the latest exposure, and that is what we want to do with all these judges. We are having a lot of capacity building programs for these judges to understand the market economy. There are market decisions they should understand. They should not sit and talk about the principles of natural justice and keep on granting adjournments. That is not so. So there are a lot of programs lined up for these judges in National Judicial Academy to expose them to the provisions of the code, and already they have been exposed. They have had some training programs, I think. And more than the judges, we need to train these resolution professionals who will be the real persons who will educate these judges. The judges will have to be enlightened, and that will come from the market forces, the people who are in the market. That is more important. And I think it's not necessary you should have the best brilliant people there. You at least whatever there, you will try to enlighten them and try to get the best out of it, because the country is going through such a stage. We can't expect them always the best to be in the best places.
So, and practically, you know, again, the code is quite self-sufficient, but you always have statutory claims. So how do you see this playing out? Again, is it, you know, we'll have to see how the bankruptcy code and the courts linked to it start practicing, or do you see a issue with respect to how this actually, you know, the challenges in other jurisdictions and under other acts, do you see that?
No, I think as far as National Company Law Tribunal is concerned, corporate insolvency will take off. But as far as individual insolvency is concerned, the subject is too wide and disparate. It's not coming under a single straight line, because different types of cases will come up. That has to be handled, and then the enforcement of that part is not done yet. That will follow later, because we want to first implement corporate insolvency, and that will follow later. And we hope to address that issue, and the government is doing right now.
I do appear for various banks in the area. So, in my understanding, with the little understanding I have, that if Section 17...
No, you have little, I have no understanding. I am a lawman.
I feel myself completely illiterate, at least in legal field.
No. So I am a draftsman, I only hold the mirror. So I have done so many acts in my life without understanding the subject.
So it's being very modest.
Very modest, right. So what happens in case when 13 proceedings are started in surrogacy? They make representation, it is decided with the speaking order, they go in essay in 17 and they get a stay. Now practically when it comes on the ground, when the rubber meets the road, what happens then if you in DRT 1 in Delhi, you get a stay, in DRT 2 you don't get a stay, bank recover entire amount. And if that refusal order, somebody goes to DRAT in Samrat Hotel, he has to deposit 75 or 50%. Now as a bank, when I interact with the bankers, they are not interested at all in the revival plan, because it is quite revival focused. So they want to know how they can get money and what time and how much. So in my personal understanding, if 17 could be enforced and officers are educated on that part, probably it will be very effective process. Even otherwise, what happens when I go for the symbolic possession, then actual possession, and then recover it, take into my custody, appoint a liquidator or receiver, then the creditor, the debtor doesn't have any role thereafter. So matter gets over then and there. Here in this process, 14 days time after application, 30 days time after RP appoints committee, committee then comes out with 180 days situation, 180 plus 90. So whether it's say 9 months thereafter, if they don't come out with a 75% plus, then it goes into liquidation. So that 9 months can be shortcut to 2-3 months time in case section 17 is little modified and enhanced. So that is my understanding probably. I may be incorrect.
Yes, no, you are right, but then the resolution plan should provide for that.
No, so I'm not talking about resolution. I'm saying I'm a creditor and the other party is a debtor. So I want to recover my money. So this actually comes into play only after 9 months, whereas because
No,
ultimately
but you are not coming under the code. You are under the code, isn't it?
any person can go, even debtor can go for resolution.
Yes.
Any person.
Yes.
I'm saying that the problem which have been which the creditors are facing is that the recovery of money, bad debt and NPA which are rising. So it is actually giving the effective mode to recover the money and make the market more viable. So I'm saying that there is a one perspective which I have, maybe incorrect, that section 17 if strengthened could also be supporting to this entire
Yes,
2016 code.
the problem with the bank finance is the bank officers are afraid of taking decisions because of your CVC. So the problem is they are not taking market decisions. Their hands are tied, so they don't want to. They are not worried. They are worried more about the retired life being affected by summons and standing in the courts. They are not given the choice decision marketplace. They have to take decisions. Sometimes some loans may go fund, then they can't be held responsible. So that problem arises that that's a problem because of bank finance. If it's not bank finance, if you raise money from the market, that issue will be solved. Your problem is because of the nationalized banks, especially coming into play.
And I think these days there is a lot of pressure from Ministry of Finance, even on the nationalized bank, to recover money as soon as possible. Because now there is a RBI audit after every quarter, which they have to put the report to the RBI auditors. So now there is a lot of pressure which I am feeling these days. And so one more, I have one question. There is a moratorium clause where it says that essential services have to be provided during the moratorium period. So now this goes on for 90 days or 180 days or 9 months time. So now I'm not very clear about what is the essential services. A company may be providing output service, it must be having some kind of input services. Now input services, I'm a service provider. I know the company is dead now, almost going to be dead. I don't know whether it's going to be revived or not. So why should I put my value at stake by providing the services to them? Now it could be either public utilities, maybe water, maybe electricity. So that could be something where public and private both are having a stake, but purely a private person is put into obligation or must provide. It appears to be quite difficult.
Let us mainly to address these utilities.
It addresses to utilities only.
Mainly that's what we had in mind. Electricity and other things shouldn't be cut down.
So in case the DSES comes to know, Reliance people, that this company is going to be over after 9 months, would it not be so difficult to convince them to, and they would also want to become a party to the entire proceedings?
Yes, because they are operational creditors.
Yes, sir. And sir, in case, in a similar situation, if I convert somebody to, in a situation what is happening these days, Unitech and all that, the person was actually booked the flats and paid a huge amount of money. Now they want to get the refund. Would they also become operational creditors?
Yes.
So they can also approach.
Yes, they can. But then I think they are having the real estate bill which has been enacted. I don't know whether it has been.
No, sir, it has not been enforced yet. There is a
That's
sunrise date.
your
for that.
remedy will be there. It's very good act. That if they enforce the act, all those problems will be solved.
But sir, it doesn't actually provide for the winding up or dissolution of a
Not
company.
winding up.
There is a specialized.
He will be only
procedure
interested in
there.
taking back the money. He will not be interested in winding up.
Right, sir,
But
right.
that will come here in operation creditors.
Because what I can foresee is that in case these operational creditors would resort to this kind of proceedings,
yes.
they can at least sell off the land of the defaulted developer
Yes.
and probably recover at least not
Yes.
100%, 50% money.
Because when the code was being drafted, everybody was in parliament was only asking how this code will prevent Malaya type episode. They were only concerned with that. If the code had been there, that would not have happened because Malaya would not have suffered such a long time. The employees would have gone to the tribunal to get it wound up because their dues have not been paid. Why they should kept on the rolls for 4 or 5 years without being paid money? So that would not have, because see, the another important thing in the code which I forgot to mention is that the test to find out whether a company is insolvent or not is a default based test, not a net worth erosion test. In SICA we face a net worth erosion test. By the time 51% of our net worth gets eroded and you discover that there is nothing for you to revive. So we went in for the default based test, the earliest possible default. Operational creditors can tell you, the financial creditors can tell you, or the debtor himself can tell. So that is the test to find out the sickness at the earliest possible opportunity. Then you address the issue so that you can revive and keep it going.
Sir, there are, sorry, last question. I'm sorry, I'm taking too much of time. The maximum problem which is faced by banks these days, at least nationalized banks, from the infrastructure companies, say in a company which is into road projects, so they get this concession agreement from the NHAI or whichever state government, and based on that they take loans, and loan is not 10, 15, 100 crores long, 1000 crores, and they continue for months time or 2 months time, and thereafter they siphon off the money. Now in this situation, how this could help in revival of the entire company, where there's no collateral, no security, there's nothing actually except the paper, like what has happened in 2G situations.
You see, you at the earliest possible opportunity you would have found out there is siphoning of money. You trigger a petition at the earliest possible opportunity. You don't wait for them to siphon off a lot of money and then wake up and then you say no. This is your code provides for the earliest trigger. Somebody can trigger it. Something you feel the company.
What happens in this? They have person A is a company which is taking the concession. They appoint B, C, D, E, F as their further subcontractors. They actually pay out the money to them, and that subcontractor doesn't have any privity with the bank. So it becomes a little difficult in that sense. So I'm just trying to understand how. What could be the operational difficulty, whether it can help the financial institution to recover the money or at least revive the company one way or the other, or in case there would be rescheduling of the payment would be for how long, whether they can wait for more than 5-10 years, and even if somebody is a stakeholder like private equity, how they will react to the situation.
In these matters will have to be decided with a creditors committee.
So, the problem with infrastructure projects has really not been on the bankruptcy code or the bankruptcy regime per se. It's for the banks to either allow for restructuring, which then goes back to the Reserve Bank, or it goes to them taking a hit. The problem, as Sir mentioned, today the most of the public sector banks are not even ready to take the hit, because then it affects how did you give the approval. Like you said, on the basis of one concession, without any assets and without any history, most of these developers didn't even have the history of developing assets and they got loans. So that has been the main pain point. So no matter what you do under the bankruptcy code, till Reserve Bank allows them to either restructure with taking a haircut, or the pressure on announcing large number of NPAs goes away from the banks, that issue by the bankruptcy code itself is not going to get resolved.
And to just add to that, like Sir mentioned, the important thing or trigger over here is the default, not being sick as it was under SICA. So it does call for a little bit of vigilance on the part of creditors, whether they are an operational or a financial creditor. In a case like this, for infrastructure projects, what we are seeing both in power and in roads, we are seeing a lot of projects being rescheduled right now, where the government is now looking at allotting certain concessions to new people because the existing concessionaire is not delivering on that. As Pratibha said, I don't necessarily, even based on the little work that we've done, I wouldn't necessarily think it's a matter of the code. It's a little bit of KYC either on the part of the authority or the bank, and on being vigilant and seeing how things are happening. Now, based on how the construction industry is, whether it is infrastructure or real estate, it does require disbursement of cash at the very threshold, at the very beginning, when there is absolutely nothing. So all you have is like barren land. You have tracts of land you have to acquire. You pay it off to the subcontractor so that he procures the material, because it being to a large extent a cash industry, they need the advances without which they don't proceed. But then even if you look at the Companies Act, there's a lot of onus and responsibility which is fixed on directors, including independent directors. So what the government has done this time is, under all of these legislations, they are putting a lot of burden on, or you should say responsibility on the private sector, that you get your act together and then we'll see how the law and business takes care of itself.
Having said that, if you have the committee of creditors, right, and if there is a willpower with the banks, the pain point has been, of course, that the bankruptcy regime doesn't work, right? Winding up doesn't really work. So if you can efficiently actually get it done in a time period and actually recover, even if it's a land bank, if you can recover the land bank and sell it, then that is the ultimate aim that the industry is pushing for.
That is surely a situation where the JP or others have faulting. But in the case of concession, actually the government land, what he's rightly pointed out is actually more for the creditors to look into before giving any this kind of loan.
There is nothing in the company, there's nothing in the company. Sometimes you can resell the concession,
I think
work
the similar
with the company.
situation they faced in 2G, because based on the telecom license they have extended financial specialty, and thereafter they found that they can't recover anything,
Right.
because there's nothing left. Sir, I have one suggestion. I try to understand that unless we have some ecosystem which electronically we can file something, petitions and serve the other party timely. I think it's 6 months time is a very, very big challenge. So are we thinking about bringing this kind of infrastructure or provision where I can e-file the petition, receive in email?
The Regulatory Tribunal, that act has been amended to provide for electronic transmission. Latest amendment provides for that.
It's a surfacey that actually that's there, but they come back and say,
Now with this registry, central registry, everything will change. Because the information utilities, you should be able to get it from the click of a button.
So the petition will also go through the information.
No, electronic filing is they're implementing.
A lot of authorities, like even Delhi High Court, the Competition Commission, a lot of them are now, I think it's taken about a year or some time, but they are getting conversant.
In fact, the amendment says anything which is registered on the registry is deemed to be a public notice. You don't need a separate notice, it's very clear. You see the latest amendment. So you can't circumvent by saying, no, I didn't get notice, evading. All those things are past. Everything is now statutorily defined.
Also, on one of the points, the committee for which serve as the chairperson, they've done a lot of interesting study with respect to revivals and winding ups in India versus what happened abroad. And here, as Sir mentioned, judges tend to take beyond statute perspective, that in the interest of workers, this should happen, in the interest of the employees, we should explore revival. And this is far beyond the point when the company probably even has a shadow of revival. Whereas abroad, I think the study talks about US, where there is absolutely no social stigma to a company being broken up into smaller pieces and then sold. But here we are still not used to that as an economic function. We would still like to preserve it. I think it comes from a social background. We like to preserve things and see if that can be revived rather than break up corporate entities and sell it into different divisions.
We have Donald Trump standing as president, and I don't think that would happen in India.
Government company be brought into the ambit of this code. Like if I've won a contract through bidding process, and there's a government company which is incorporated by a state or a central government, can I invoke this against the government company or a PSU?
I don't think there is any
Code does not prevent that, but I think I have to examine the Companies Act from that other provisions of the Companies Act. There is nothing in the code which exempts the government companies, but I should see the Companies Act whether there is any provision which impacts that.
I can cite one thing, illustration. there was an issue which came up for the consideration for the High Court, Delhi High Court. Just the CP was sitting about the expeditious recovery.
Yeah.
So there is a PP Act interpretation came up for the consideration.
Yeah.
The PP Act consideration was that whether this PP Act can be resorted by one government company against another government company. So they brought the distinction of a statutory corporation, corporation sole, corporation aggregate, and thereafter they decided that no, you can't resort this summary procedure against the government. Government not supposed to be at the receiving end, which is actually representing the public. In the absence of void, I don't think, there must be some law, after research we can find that yes, it will be very difficult to recover, because you can't take a coercive measure against the government.
Right. So if you look at the flow, I think would be corporate person and corporate debtor. Corporate debtor contemplates any corporate person, and corporate person is company, LLP, or any other person incorporated with limited liability under any law for the time being in force, excluding financial service provider. So there's enough room over there for you to argue that even a statutory corporation will be there. But practically that might not happen, because the minute you did that, there is a possibility, assuming that, let's say it's something like a company where government has invested shares, which is also a listed company, not just created through an act of parliament, there is a possibility that government would itself infuse more funds into it. So, and when you're looking at the trigger for this is really default. So for default to happen, you're looking at a statutory corporation or a central government company defaulting to, say, State Bank of India. The minute that happened, there'll be some minister or some bureaucrat who will write to State Bank of India and saying that, come on, you need to withdraw this.
I one thing. There's a judgment by the Supreme Court where it says the secretaries of the ministries have to first.
No, there's an official memorandum to that effect.
Yeah.
And even CPC, I think there is a provision that if for instance, Ministry of Railways cannot file a recovery against Ministry of Telecom, vice versa. Ministry of Finance cannot, Finance Ministry Revenue can recover from government companies, but departments, inter-department disputes cannot be resolved through court. It has to be at the secretary level. There is an office memorandum to this effect.
Quite unlike Delhi and Central.
No, but center and state or two states can always fight. There is no prohibition over there.
Okay, on that note, unless, we can always carry on these questions in the room. But thank you very much, sir, for taking out the time and enlightening us on a very important legislative piece of work that you've been involved in. And we look forward to this becoming very well used by 2017, as the finance minister has guided us. Maybe we'll bother you again then, as we start using it. Thank you, everybody. We're going to wind up the proceedings right now.
Thank you.